special needs children. So when you think about what a set of documents include, it's a will, a power of attorney, healthcare power of attorney, and a living will. And so before somebody even puts the chat in, there's usually a question about, well, wait a minute, I've just gone to 6 or 7 webinars about living trust. Don't I need to avoid probate and get a living trust? And what I would say is that in Pennsylvania, the probate fees for someone in our county, for instance, if you have $1 million estate, the probate fee is going to be probably under $1,000. And so the probate process, which is making your will a public document, takes about 15 minutes. And the idea of, having a living trust to avoid probate is sometimes over exaggerated. There are really important ways to use a living trust, but generally, that is not what's going to prevent you from having exposure to long-term care expenses. Putting a house or any money in a living trust does not protect your money or your home. So generally, the will is going to be at the financial power of attorney, the healthcare power of attorney, and the living will. So when you think about the war stories, the things that we will see within our office, a good example of why a financial power of attorney is such an important document as it relates to long-term care expenses is a very typical situation where perhaps one spouse is in a nursing home and the other spouse is in the community. And perhaps it's the husband in the nursing home and the wife is sitting in front of me. And the husband, because of a sudden health event, is not going to be able to return home. And all of a sudden, the concern is, what are we going to do to pay the $12,000 a month nursing home bill? And so when we think about making a list of all the assets, and we'll go into a little more detail when we talk about Medicaid, but the biggest asset for many of my clients is their home. And the idea of protecting that home for that healthy spouse is really one of the most important goals for long-term care planning. And the idea of being able to protect 100% of the house for that wife in that example is absolutely easily achieved if you've got a financial power of attorney that actually allows carefully planned gifts. And so when we don't have a financial power of attorney and I'm looking at a spouse whose husband or wife is in a nursing home, I have to say to them, hopefully we can get a power of attorney signed so that we can move assets, including the house, over to your name alone. And so that way we can avoid estate recovery. If the home has a value higher than what Medicaid allows, it allows that unlimited value home to be protected. And also it's an important planning technique because if the house is sold once that husband's on Medicaid, the wife in that example gets the benefit of all those proceeds. That's all possible because the power of attorney is drafted in a way to support the long-term care plan if it's done properly. And if it doesn't exist and the husband can't sign a power of attorney, we're forced to do a guardianship and may not get those quick and ultimate results that we really want. The financial power of attorney, if you had to have one document, that would be the one thing to get done, which is actually compared with what most people think, which is if I'm going to get one document done, I'm going to get a will done. It's important to get both. And the war stories that relate to the wills really relate to what happens when you don't have a will. So a good example is we have many retirees in our area that might have accumulated big blocks of stock because they've worked for big companies in our area. And if that husband were to pass away or that wife were to pass away owning a block of stock, everybody's assuming in the family that that stock just goes to the surviving spouse, only to then realize, wait a minute, there's no will. Under intestacy, that spouse could have married 60 years. And unfortunately, the wife in that case or the husband in that case will get the first 30,000 and then split the balance with the children. The law does not assume that 100% goes to a spouse. So if that's what you wanted, then you actually have to have a will. And when I referred to the will as a way to avoid long-term care expenses, if you have a spouse who's not well, your will as the healthy spouse really needs to have some important protection in there so that if you want to continue to make gifts to that surviving spouse who's ill, you create a supplemental needs trust. If you take that step and fix the will, so it's not a sweetheart will that says, I give everything to my husband in that example where the husband was in a nursing home, you can still have a trust if you choose to, that would actually benefit that spouse and still allow the spouse to go on Medicaid. You can only do that if you proactively plan for the ill spouse. The other typical war story is that sometimes someone may come into our office and the person may have passed away with a surviving child who has special needs. And those special needs are the equivalent of long-term care expenses. If that child is relying on Medicaid for his or her public benefits and their health insurance, if that parent didn't do proper planning, then the long-term care expenses, the Medicaid for that surviving child can be jeopardized because the inheritance is uncontrolled and just going directly to the child. All of these things are part of what we do when we carefully review the assets, your family tree, and your goals, so that these documents aren't just things that sit in a folder in case you die. They're documents that are in a folder that will be important not only for you, but that spouse, that child, or even the the special needs child. So you cannot understate the importance of getting really good documents. So what's the solution? The solution is to, after this webinar, go pull out those, dusty old envelopes and files and see what your documents look like. What amazes me is that sometimes clients will come in and laugh and say, you know what, I didn't even have kids at the time I did these documents, or I might have only had one child and now I have four. Or they actually talk about having special needs children, one or more, only having never had done documents, and the parents may be, more than 60 to 70 years of age. And I wonder, what vulnerability there existed for all those decades. If you have only a will, that's like walking around with no top on and only pants. The idea is that, yeah, we're all going to pass away, and it's to your advantage to make sure your instructions are clearly understood and that you've got the proactive planning in your will. But if you don't have a financial power of attorney, your real vulnerability isn't the 4.5% inheritance tax that may apply or will apply when you die and your children get your inheritance, their inheritance. What your vulnerability is that if you become chronically ill, or you are already chronically ill, that you actually progress to needing a high level of care, it's the long-term care expenses that really take apart people's portfolios. It's the long-term care expenses that make people have to resort to the Medicaid as the safety net. So getting a financial power of attorney is important. And if you don't have a healthcare power of attorney, a living will, and a HIPAA, that has not necessarily anything to do with managing long-term care expenses, but it's just an important part. And what I would say is that you don't want to have a set of documents where you don't have the right people as your surrogate decision makers. So when you are not able to give informed consent for an important medical decision, you really want to be saying who is making the decision. And if you have a blended family with a second or later spouse and children from a prior marriage or relationship and nobody gets along, I can't understate the importance of that document and making sure that you put down what you want. And, for these other documents, as I sort of mentioned, maybe it doesn't have direct, linkage to how to pay for long-term care expenses, other than what my husband says, which is in his healthcare power of attorney, in his living will, he was joking that he wanted me to just put him on an ice float and put him off as his long-term care plan. So I don't know, maybe that's one way to look at it. Okay, so let's talk about our next possible solution, which is Medicare. And it's unfortunate that Medicare and Medicaid sound so similar because people assume that they're both the equivalent or very, very, very much the same. They're not. Medicare is insurance, and insurance coverage, whether it's through an employer or a policy that you get on your own or Medicare, it's a contract between an insurance company and the insured. And so things are either covered or they're not, or there are co-pays and deductibles, but it's really clear that there's a contract. And so Medicare is an insurance program that's run by the government at the federal level, by CMS, the Center for Medicare and Medicaid Services. And when an individual gets to be 65 years of age, they get to enroll in Medicare and have their health insurance. There are other people who may be disabled and after a 2-year period will be able to access Medicare as well. So Medicare is going to have insurance coverage for people that have finally gotten to be eligible to get insurance under the contract. And when you think about what sometimes happens is that people assume this insurance is what their insurance is for long-term care expenses. Many times people have been relying on Medicare as their long-term care coverage. They're assuming if they ever need to go into a nursing home, that that's what's going to pay the bill. And so many families have been surprised to learn that Medicare does have a benefit under the contract to pay for long-term care expenses in a skilled nursing facility, but it's a maximum benefit of 100 days. And many of them are surprised that there may be cost sharing after day 20. And for other types of Medicare enrollees, it may even be before then. So if you're assuming that you've got this covered because of Medicare, it's often a surprise to find out that there's just very limited coverage under Medicare. The other thing that's very surprising is that many people that finally get to purchase Medicare coverage don't understand that there was a choice they made when they enrolled for Medicare. They have no idea at the time of enrollment that there was a fork in the road, that they could elect to have coverage under the traditional or the original Medicare, or that they may actually make a choice to participate in managed care Medicare, which is Medicare Advantage. And so when I'm talking to a group, when I get to see the group, I'll actually ask the audience to raise your hand if you have traditional or original Medicare, and then people will raise their hand, some people, and then I'll say, okay, now how many of you have Medicare Advantage? And some people will raise their hand. And then just as many don't raise their hand because they're not sure. Why is it important for you to understand what your insurance is? Because it really affects your long-term care expenses. So under either type of Medicare coverage, there's the limit of 100 days. But if you are under the Medicare Advantage, what's really important to know is what the cost sharing obligations are. And so you have to actually look at every year when your coverage rolls over, what is it that you're going to be expected to pay at the hospital, at the skilled nursing facility in terms of the cost sharing. And unlike traditional or original Medicare, when combined with a Medigap or supplemental policy, with Medicare Advantage, you will have cost sharing, meaning you will get bills that you are going to have to pay as compared with somebody with the Medicare, traditional Medicare or original Medicare and Medigap. There will be complete coverage. At some point though, either under the traditional or the Medicare Advantage, you may find that you actually are at a nursing home and finding out that you have no longer any benefit under the Medicare because you have plateaued. And so just to alert you to a consumer issue, the idea is that if you are plateauing, that means that the insurance company under Medicare Advantage or the facility for the traditional Medicare, that someone's determined that you're no longer benefiting from the therapy at the skilled nursing facility. And what I would want you to write down is something referred to as the JIMO settlement and the concept of maintenance Medicare. For many of my clients, the time in rehab is the most important part of their recovery. And they have a need for intense therapy, or sometimes they're so ill they can't tolerate the intense therapy until they get a little bit better. But the idea is that we want somebody to have the whole 100 days or as much as we can to really maintain or improve their conditioning. And so the JIMO settlement is an important advocacy tool so that don't let a facility terminate your benefits too quickly. Make sure that you try to maximize the Medicare and get as much skilled therapy as you can. And that applies for both Medicare Advantage and traditional Medicare. There's another advocacy tip for traditional or original Medicare. In order to even trigger the maintenance Medicare for that 100 days, you have to have a 3-day qualifying stay in a hospital. Well, you may have heard about the concept of observational beds. And the idea is that if you're in a hospital but under observation and you're there for 10 days, it will not trigger your benefit to cover your long-term care expenses for therapy. When you, a spouse or a family member, are in a hospital and it's under observation, you must make sure that you work to trigger eligibility for this therapy by making sure you have an admission for 3 days. So these Medicare advocacy issues, I would refer you to the Center of Medicare Advocacy, CMA. They have self-help packets that are just really incredible. And then, again, look at the type of insurance you have and know that every single year you have to reshop, and that if you are not actually within the Medicare, if you are within Medicare Advantage, there's limited opportunities to really go back to original Medicare. But if you're about to turn 65 and enroll, please know that I do have a preference for traditional or original Medicare. I see there's one question, so let's just see what the, okay, so just going back to the estate planning documents, the question is, can I address the issues for single women with these documents? Yeah, and I think what people need to realize is that if you're a single person, whether it's a male or female, the idea is that you may not actually have the support as the caregiver or the spouse as a caregiver or a spouse as an additional source of income. And so as a single person, it's not only the idea of managing bills and taking care of insurance and filing tax returns. You can actually craft these documents so that they are your safety net, so that if when you're vulnerable, you get to say what type of care you want, who the chain of command is, and exactly how you want your assets to be used. And the term solo senior applies to people that may not have any family members in the area or perhaps don't have any children, and they want to make sure that these documents select agents or surrogate decision makers that are going to be there. And sometimes if there are no family members available, we have to work really hard to make sure that we identify the right surrogate decision makers. And there are professionals that can serve in either a financial role or the healthcare role. And that's absolutely how you build your own safety net. So it's not just to protect your assets from long-term care, it's to protect yourself from the experience of long-term care and navigating the healthcare system. Okay, so we talked about Medicare, so let's go and talk about Medicaid. So Medicaid is not anything like Medicare. Medicaid is how people that are low assets and low income or those who are disabled will actually get health insurance. But unlike Medicare, which is an insurance program run by the federal government, Medicaid is a joint federal and state program. And this is a program that is really complicated. The idea is that Medicaid can pay for general health insurance. And if you have a family member or an adult child, maybe with special needs, or a younger child with special needs, you may have an access card, which in Pennsylvania is a Medicaid health insurance card. In terms of what we're covering today, the idea is to understand that Medicaid can have lots of uses in other areas, but for long-term care expenses, Medicaid is a big deal. And where we find clients most confused relates to the transfer rules, the look-back rules, the idea that it's too late and that Medicaid is just not available to them to pay for long-term care. And what is so reassuring to the families is that when we sit down and actually explain to them how Medicaid is not just a safety net for those that are already the poorest of the poor with no more than $2,000, Medicaid was designed to be a safety net for the middle class. There are things inside of Medicaid that are extremely important to understand, especially if you're married, so that you recognize the opportunity to make sure that Medicaid is obtained as quickly as you possibly can. So when you think about getting good advice on how to look at Medicaid as a possible way to pay for long-term care, some families are disappointed to find that the facilities aren't going to be equipped to give them advice. Maybe the facility can handle a Medicaid application, but they're certainly not going to be able to give you calculations on when the healthy spouse may actually be entitled to apply. And we'll go through a couple examples that illustrate why that's such a hard thing to figure out. The facility isn't going to be able to explain to perhaps a single person how to utilize the Medicaid rules to maybe protect a home or protect a sibling who is living in the home, or utilize some of the assets for a disabled family member. There are many things built into Medicaid that have come as a complete surprise. And so, yes, Medicaid is a solution to pay for long-term care expenses, but it has to be put in the context of really careful counseling on how to make sure that the assets that you have are used for not only to support your care, but to also integrate with the Medicaid planning that is often needed to protect some of the funds for the surviving spouse or for the other family members. So let's talk about what happens with a married couple if a husband is actually in a long-term care facility, a nursing home. It's possible that even with significant assets, the spouse in the community may be allowed to apply for Medicaid right away. So let's give you an example. So if you have a husband and a wife, and we'll pick on the wife this time, the wife is in Fair Acres or Pocopson, the county homes for in our area, and perhaps they have a home worth $750,000. It's appreciated. And perhaps the husband has a qualified account of another $750,000. And then perhaps they have some other investments outside of the husband's, like IRA, of $200,000. That doesn't sound like a Medicaid case. But if there is a properly drafted power of attorney, that home with the value of $750,000 or whatever it is will be protected. And in Pennsylvania, the husband who has a qualified account of $750,000, that's considered to be an exempt asset. And then the other assets that I listed, $200,000 of investments, that community spouse, the husband, is entitled to one half of them, almost to the point of $125,000. So that leaves very little in excess of what the husband is going to get. In that case, I guess if it's $200,000, the husband will get one half, $100,000. But there is a way to actually absorb the money, the rest of the investments, to actually help that spouse who's in the community. So many times the facilities or even Medicaid would say, well, okay, let's fund your burial accounts. But there are things that are beyond the burial account that are very important to understand. And one of the ideas is something called a DRA annuity. At some point in the not too distant future, we'll do 5 solutions under Medicaid, and you'll come to understand the planning opportunities for that. Just suffice it to say that if you're married and in now or in the future, you have a spouse that's actually in a facility, it's never too early and never too late to actually consider what Medicaid planning means for you. For single people, Medicaid as a safety net is extremely important as well. And even though there's not a community spouse, the idea is that there are all of these exceptions to Medicaid, which would allow us to utilize some of the money that would otherwise go to the nursing home, but for the benefit of a sibling that the house may go to the sibling, or perhaps as a disabled family member. Where the interesting question comes up is what if you have a single person and they have $500,000 of savings and no home? And the question is, what does Medicaid planning do for that single person? Well, under current planning techniques, there is a way to protect about 50% of those resources. And the question that everybody needs to answer for themselves is, do they feel like it's appropriate to actually accelerate Medicaid eligibility? In other words, if somebody has $500,000, is it acceptable to take half of those resources and protect them from long-term care expenses while the person's in a facility? It's a political question, but for many of the families, it's a practical question. And for those single people, what I would say is that many times they'll say, we're happy to strike a balance. We never expected to be on Medicaid, that they don't expect everything to be protected and have Medicaid start immediately. And that with Medicaid planning, it strikes a balance that feels fair to them. All of that's possible, though, as long as the financial power of attorney is in place and actually has the right provisions. You keep hearing me say that the financial power of attorney is critical. And this is another example of how you really have to have the right financial power of attorney. So for Medicaid solutions during the pandemic, what's been really very gratifying is the idea of people, the families coming in and say, please do everything you can to keep my spouse, my parent at home. And the idea is that you need to understand in Pennsylvania, we can certainly use Medicaid in the community as long as the person who is ill has income under a certain cap. And the cap is not very high, it's under $2,500, but there is a way in certain cases to have a little bit of a cushion up to $500. There is a way to utilize something called the LIFE program. And there are important Medicaid planning strategies, especially if you're that healthy spouse, where we get to leverage your work with the home and community-based services in Medicaid. So Medicaid and long-term care expenses, they are partners in the analysis and you can't ignore it. So what's the solution? The idea is to make sure that if you really are going to anticipate paying for long-term care, you need to know that Medicaid in our system right now has a fundamental role in that, even if you have assets. And that in order to access these benefits, the idea of you being able to drive that bus is very unlikely. You will have to be what's called nursing facility clinically eligible, NFCE. And in order to make sure we've got somebody who's able to access the Medicaid, it's quite a process. You're going to want to have the right person as the agent, and the document must include certain provisions to get that, to line those things up. Safety net for long-term care in certain cases, that refers to the home and community base with the income cap. So if you have somebody that you're taking care of that's on the continuum of care, let's just talk about what that concept is that the idea is that we all start out hopefully independent, and then as we might get a diagnosis or have a sudden medical event, we may actually need support, and that support helps us with activities of daily living. So if you're taking care of somebody and they need help with toileting, eating, transferring, dressing, medication management, those types of things, you're somebody that really should be looking at how to proactively or reactively look at Medicaid to stretch your money to keep you in the least restrictive setting that's really safe. So again, the financial power of attorney is a big deal. I think we do have a question about, so back to the estate planning. Could you discuss about roughly about the fees for those documents? And so what I would say is that you can ask 5 different lawyers what a set of documents cost, and you will get 5 different answers. For me, I can tell you our process and give you a little bit of a range in terms of what the foundation, the fundamental documents are. So our process starts with the assumption that because we're so busy, we really have working appointments for clients that are ready to get things done. So we've given them an intake form and a list of items needed and asked them to pull those things together as best they can before the initial consultation. And then during the initial consultation, we take an hour, hour and a half to go over what do their current documents look like? What does the family tree look like? What are the things that you're worried about? How are we going to pay for your long-term care? And after I get through all of that, including looking at their asset titles, the beneficiary designations, the projected inheritance tax, the projected income tax, then I can actually put together a plan for their estate plan and their long-term care planning. If it's a simple set of documents, the essential set of documents is probably, I would say, $1,500, and would include the power of attorney, the healthcare power of attorney, the HIPAA, the living will, the financial power of attorney, and the will. Sometimes the foundation set, the very basic ones, just don't hit the mark. And so what you'll find is that there is a need to do certain kinds of planning beyond that bare minimum. But what's important for you to recognize is that even if it's the bare minimum, when documents are prepared from our firm and other, CELAs, the idea is that these documents are not going to be 2-page powers of attorney that you could get on the internet. Our powers of attorney are over 20 pages long and include the provisions that function as long-term care insurance for the families that are going to have health crises. The idea is that these powers of attorney are designed to be the arrows in my quiver so that if I need to use different techniques, I've already provided for it inside my power of attorney. Our documents also include, even with the most basic will, a standby supplemental needs trust, so that if we have somebody who's unexpectedly disabled when one of our clients dies, that we can actually utilize a standby supplemental needs trust. There are things built into our healthcare power of attorney and our living will that are not typical. And the idea is that what we do is not typical. And so even with the most foundation set of documents, it's not meant to be, an insignificant process or an insignificant product. The other question was, what about the Social Security Administration benefits in terms of Medicaid? Okay, so that is a question that is sort of like a foot wide and a mile deep. SSI is Social Security, is supplemental income for people that are disabled. And the idea is, again, that if someone's on Medicaid, they may also be on SSI, and SSI results in the immediate qualification for Medicaid. So in certain types of cases, people that are on Medicaid are also on SSI. In terms of the benefits for SSI, that is usually a monthly check that comes in, and in Pennsylvania, we have a state supplement. For purposes of today, what pays for long-term care expenses is not the eligibility for that monthly pension, but actually the Medicaid, which has an economic value that's usually much higher than the monthly benefit that's coming out to the SSI recipient. So those are great questions. Okay, so we're going to leave the world of Medicaid, and we're going to talk about the idea of the veterans benefit. And when you think about veterans benefits and this enormous organization, the Veterans Administration, it's just very big, very powerful, very confusing. For our purposes, we're focusing on how to pay for long-term care expenses. And so the idea is to understand that veterans who have are already in the healthcare system because they've accessed the healthcare system through having a rated injury and are already getting the benefits and the treatment through the VA, there is a category of benefit called extended care. And it's also available to people that are not necessarily have a rated injury, but because of financial constraints are also going to access the healthcare system and also the extended benefits. So extended benefits are incredibly important because whether it's the home health care, whether it's the adult daycare, whether it's the respite for the caregiver, these are things that may be available without having to accelerate any eligibility based on income or assets, especially if you have a vet that has an injury that qualifies. In addition to the extended care, there is a type of pension within the Veterans Administration called aid and attendance. It's confusing because most people think of a pension as being an income stream from a company after service of many years. The pension may have vested, and then you're entitled to a monthly pension. Well, those types of pensions are very hard to find. The VA pension, the aid and attendance, is actually not a pension in that way. The VA aid and attendance program is actually much more like the Medicaid program, which is based on having low assets. And it's one of the important elements to get aid and attendance is not only that you meet the asset requirements, but you also have to have something occurring in your income. It's not that your income has to be below a certain amount, as with Medicaid, under the number that was under $2,500. But in order to actually achieve aid and attendance, your recurring monthly income has to be consumed by unreimbursed medical expenses. And so I have many people come in that are either paying $7,500 to a personal care residence, $10,000 to a nursing home, maybe $12,000 for round the clock care, for home health care. Their income is consumed by these unreimbursed medical expenses. But not everyone and not every veteran is going to be eligible for the monthly aid and attendance benefit. There's a requirement that they have served an active wartime. There has to be active duty for at least 90 days and 1 day during an active war period. And that list of what the active war periods is available on our website, and it's also available on Google. And the idea is that if you meet that threshold requirement, then you may actually apply with other eligibility rules and get a benefit. And the benefit is remarkable because for a married vet, it could be $2,000, so actually a little bit more, of tax-free income every month. Or if you have a surviving spouse of a wartime vet, then you can actually get $1,244 a month tax-free. So for high net worth people that have, the plan of self-insuring for whatever their long-term care expenses are, maybe $2,000 a month isn't significant, but for many of my clients, this is really significant. And the idea is that if our goal is to keep people in the least restrictive setting, there is a value to having the aid and attendance through the Veterans Administration help our wartime vets or our surviving spouses stay at a level of care called personal care, like a sunrise. And so this Veterans Administration pension can also pay adult children who are serving as caregivers to a parent. And so when you think about this aid and attendance, it's really important to understand that continuum of care I mentioned, but that this is one benefit, if you can trigger it, that is actually available throughout the entire continuum of care. So if you have a wartime veteran, or if you have a surviving spouse, you need to know that in October of 2018, the rules changed. Unexpectedly for some, the Veterans Administration decided to give everybody, I think it was 90 days notice, that within 90 days, the entire set of rules would change for aid and attendance. And back in 2018, a 3-year look back was implemented for if you apply for aid and attendance. The question is, have you divested any assets, gifted any assets within the past 3 years? And the VA rules did impose a transfer penalty if you did actually make gifts. And the VA did clarify what unreimbursed medical expenses mean. And the VA did clarify that people can have a threshold of certain assets up to $123,000 and still be eligible for the aid and attendance pension. The reason why the rules were changed is that there was a really strong feeling within the Veterans Administration that the people that were accessing the aid and attendance were getting guided by too many people that were utilizing different techniques for immediate veterans eligibility. And so rather than striking a balance, the idea is that if, before the rules changed, if you had $500,000, you could simply divest $500,000 and then have the VA benefit immediately. Those days are gone. However, many wartime vets come in and we're still able to do significant work in planning for them. And the idea is that by carefully understanding the rules, there are still many things that are permitted by the new rules to take care of that wartime vet or the wartime vet spouse and protect the house and many of the other things that are the goals of clients when they come in. So in terms of the Veterans Administration, whether or not you or your family member is going to qualify for wartime status, that's the key to accessing the aid and attendance benefit. And are they on the continuum of care? Just recall the idea is that the person's income is consumed by unreimbursed medical expenses. And for people that are higher on the continuum of care, meaning that they need support in lots of those activities of daily living, that's not hard to actually meet that requirement. Meeting the asset requirement, meeting the look back requirement, avoiding the transfer penalties, those are all things for another day. But just understand that with those rules, the VA really clarified and made very many things so much simpler to understand. So as it wasn't a perfect solution, it gave us a lot of clarity. If you want to stay out of a nursing home during the pandemic, what we found is that this is also another important benefit that we may be able to tap to keep family members from having to transition to a nursing facility. And again, the extended care under the VA healthcare system, the idea of getting home health care and perhaps even needing it to be increased, all of that is a conversation with the Veterans Administration, the social worker, and we've seen a lot of flexibility in helping people with those needs. Again, the financial power of attorney is a big deal in order to access these benefits. If our wartime vet is needing support and the financial power of attorney, the agent under the document doesn't have the right document, accessing these benefits may not be possible. So getting the set of documents that includes the properly drafted financial power of attorney not only was the key to be able to do Medicaid planning for a spouse, for a sibling, for a disabled child, for a single person, it's also the solution for somebody who may want to access the Veterans Aid and Attendance. Okay, reverse mortgage. This is something that is actually a very rare occurrence in real life. It's also one of the most commonly asked questions. And so people really feel like one of their biggest assets, their home, is potentially a source of money and funds for their long-term care expenses. And what they don't realize is that because of the real estate crisis and because of a couple other factors, reverse mortgages have really evolved to have some real barriers to utilizing them. So what do I mean? If we have a home that is actually owned by someone who may be 89 years old and the house is worth $500,000, if that person wants to access the equity in their home, from their point of view, they mean $500,000. From the lender's point of view, the equity is going to be much less. And the reason why it's much less is that reverse mortgages are set up to be what's called non-recourse loans. That means that at the end of the day, if the amount borrowed is more, grows to be higher than the value of the home, that there's no one else who's going to be on the hook to pay back that debt. So in our cases, 10 years ago, there were many houses that were appraised to be very, very valuable. And when in fact the value crashed. And on the basis of it being a very valuable house, in our example, maybe they were given borrowing power up to, $400,000. And then as the person utilized it, the interest accrued, and then the house value collapsed, many of the lenders found themselves owning houses that actually had less value than the amount of the debt. So in order to adjust for that, the amount that's available to borrow has been regulated and actually reduced. The ratios for the amount of borrowing has declined. What's always been important to understand is that my example of the woman with the equity in her house, what she doesn't realize is that the fees to now access the more limited amount of equity, the fees are significant. So if you were to get a traditional mortgage and go to a bank and get a mortgage because you're going to purchase a house, you may pay fees of $5,000 to $6,000. But if you're actually going to have a reverse mortgage, you're going to have to refinance any debt that's on your home as well. Plus, you're going to have fees that could be as high as between, I would say, $17,000 to $20,000 for the transaction. What many people don't realize is before they ask about the reverse mortgages is that been decreased, and the fees are really prohibitive. And more importantly, what we find is that if we have somebody that really is relying on this mortgage and this equity to pay for home health care that may cost $10,000 to $12,000 a month if it's 24-hour 7 care, we're not giving somebody a long-term solution by accessing a limited amount of equity. And it's heartbreaking because the real estate taxes in our area are so significant and the borrowing power so little that what we find is that this is actually not a good use for paying for long-term care expenses. There's a variation on a theme though. And so we have had many adult children who are serving as caregivers, and some of them are being paid, some of them are deferring the payment. We have a lot of children whose parents may have very limited cash flow, and they're helping that parent maintain the house, or they may be paying for home health care aides themselves. And rather than a commercial mortgage, there are private reverse mortgages where the adult child may act as a lender. And by doing that, we're taking care of the adult child. And if the adult child is going to have protection for assisting the parent, we want to make sure that when the house is sold, that the expectation of repaying that child is not only between the parent and the child, but written down so that Medicaid doesn't have any questions about whether or not this looks like a gift. So for our families where the adult children have the financial ability to help parents, we want to structure the arrangement carefully so that we're protecting not only the parent, but the child who's really allowing that parent to remain in the community and really take care of that. So in terms of the reverse mortgage and the solution, the idea is that really the commercial mortgage is difficult, but the private one is probably the solution. So those were our 5 solutions, and now we're talking about the 6th, which is your bonus. And the idea is that something that you may never have heard about before is actually one of the most important things as a solution for paying for the long-term care. And even for clients that are paying privately for, $13,000 in a single deluxe nursing home facility, the fact that they may be paying in excess of $10,000, $12,000 doesn't guarantee that they're actually getting good quality care. And the idea is that it's not enough to know how to pay for long-term care. And we certainly have a lot of expertise in Medicare, Medicaid, veterans benefits, utilizing long-term care insurance, leveraging what your adult children are providing by way of care or financial contribution. But we also have a lot of experience in actually helping families find and get the highest quality care and navigate this really complex healthcare system. So life care planning is a model of elder law work that really is clear in terms of what the goal is. So the goal is to do all of the asset protection planning and the idea of funding the long-term care. But the idea is to say that is something that will be analyzed after we decide what the least restrictive care for the client is. And then how do we make sure that we get the best provider for that level of care? And knowing that things are always going to be complex, even with the best providers, how do we actually navigate through different levels on that continuum of care, whether someone goes to a hospital, back to home, or hospital to nursing facility, or move from home to a continuing care retirement community. The idea is that all of these things require an understanding that the continuum of care is very predictable. Some of the landmines are very predictable. And wouldn't it be great to actually have somebody telling you about the care issues that you're going to anticipate? And so for our firm, we have a holistic approach. And the idea is the solution is not to just know how to spend your money or access care with Medicaid, but to actually know how to get good quality care. So our team includes a social worker and an elder law attorney that's certified and a paralegal. And the idea is that your team is actually looking at this as a multidimensional, holistic approach. And so we actually have many clients that we have helped not only stay home, but if they do need a higher level of care, then we make sure that there's a careful transition. That's another way of saying that when you get a great set of documents and that you proactively select your best surrogate decision makers, the best people who will work as your financial power of attorney, your healthcare power of attorney, your living will, the best people who will be the executor and the trustee for maybe a spouse who's ill or a special needs child. And then you make sure you get the best Medicare coverage you can and understand the advocacy tips that you need to be aware of. And then know that if you really go on the continuum of care, you have to, or your surrogate decision maker has to get engaged to make sure that your care planning is on target. And the idea is to really make sure that every financial, medical, legal decision is coordinated to the goal of taking care of you, your spouse, your home, and your legacy. And all of that is really just peace of mind. So the solution is really the idea to just make sure that you do something now to get peace of mind. If I haven't said it enough, the idea is that you will need a great set of documents and a great set of people working on your behalf, and your surrogate decision makers and a qualified elder law attorney are part of those team members. I think there's one other question that I'll answer. How about annuity with long-term care built into it? This is a great question. So there'll be, a whole nother hour where we talk about long-term care insurance. And the idea is that many people are going to assume that they can go and get long-term care insurance only to find that they have health issues that prevent them from meeting the medical underwriting for long-term care insurance. And so really the time to explore long-term care insurance is not when you're 75, it's actually when you're in the late 50s, early 60s. And the idea is that 10 to 15 years ago, there were many, many companies that were producing long-term care insurance products. The number of producers has dwindled and it's very few. There are very few companies that will sell long-term care insurance now. And the ones that do are going to be very different than the ones that were 10 or 15 years ago, where you might have been able to get a policy that says, we will pay this daily benefit until you pass away. Those lifetime benefits don't exist. And so what has happened is that in order to encourage people to get long-term care insurance, there was a change in the law in 2006 that said, if you do get long-term care insurance and it's a partnership policy, it actually can dovetail with the Medicaid rules. So you can avoid a state recovery, you can actually have additional assets. And there are some partnership policies, but the more important development was that there were some products such as annuities or life insurance products that were designed to have an additional part of that contract, a rider that would say, if you need to accelerate the death benefit under the life insurance, you could use that for your long-term care expenses. Or if you had annuity, you had a rider that says this annuity can also help fund long-term care expenses. And so there's parts of these two types of products where there's a contract that says, if you qualify because you need long-term care because you have problems with 2 activities of daily living or perhaps cognitive impairment, guess what? These insurance policies and these annuity products can actually pay a nice monthly benefit to help pay for your care. And then, my comment for that is absolutely great in terms of the financial planning that really should be done, and as part of your estate planning, when you're thinking about how to finance long-term care, every single person who at age 60 is saying, I'm never going to a nursing home. Well, if you really mean that, then you need to actually carefully look at these products so that you don't have to rely on Medicaid. And if you really want to stay home and your income is going to be beyond the cap that Medicaid has, this is going to be the way to do it. So I'm all for, and I encourage people to look at these products. But for many of my clients, the ship has sailed. they're at an age where it's too expensive because of their age, or they actually don't have the health needed for the underwriting. There's also another category of people that have long-term care insurance, and then they're continuously getting letters. Your premiums are going up. Your premiums, you have a choice, reduce your coverage or perhaps even cancel. What I would say is do not cancel your policy if you can afford it, and carefully look at these letters and get good understanding about what your daily benefit is. And for many, a special call just to make sure we review the letters and give good advice as to how to structure their decisions so that they don't completely eliminate the insurance as a safety net. So how do I feel about the annuities with long-term care insurance? I think it's a really great product that can be designed to dovetail with the type of assets that you have and whether you're single or a married person. And what I often find is that we get pulled into the conversation by financial advisors who know how to actually utilize not only the insurance benefits, but also the Medicare, the veterans, and the Medicare. Okay, so in terms of all that, we're over, but thank you so much for joining me today. And I'm really glad that we got to pack in all of that within 1 hour. If you have any questions, feel free to email them since our time is over, and I'll be happy to respond to the emails. But thank you very much for coming today.